My name is Abby, and I will be talking about the case of Boy Scouts of America versus Dale today. A summary of this case is this is in regards to the constitutional freedom of association, in which this case it was about private organizations being allowed to discriminate against characters of a group if they feel like it was against the viewpoints of that group. And specifically in this case, that was about the LGBTQ community. And this was very controversial. This was in the year 2000, and there were a lot of LGBTQ legislation going on during that time. So this case is about this man, James Dale. He's on the bottom right there. He was at a prestigious university in which he was an active member of the Lesbian Gay Alliance Club, and he was also a scoutmaster, assistant scoutmaster for many years. And once the Boy Scouts of America Association found out that Mr. Dale was a part of this LGBTQ group on campus, he was fired for finding out that he was in that community. And the question that was brought to the first court was, does the application of New Jersey's public accommodation law violate the Boy Scouts of America's First Amendment right of expressive association to bar homosexual people from serving as troop leaders? So just a summary of the First Amendment, because that's what goes into this case, is that the First Amendment right to expressive association is very important, but was not often used in cases. And the state statute was a state statute put into place to prevent discrimination on the basis of a number of things, and sexual orientation was one of those things. And just recap of the First Amendment, it says that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of people peacefully to assemble and to petition the government for redress or grievances. So in this case, it's a battle between the discrimination and if they have the right to not want Mr. Dale in their to be the assistant scoutmaster because of his sexual orientation. The lower court, the first court it went to, was the New Jersey Superior Court, and this court says that it's not applicable because Boy Scouts of America, BSA, was not a public accommodation at all. It was a private organization, so therefore it doesn't apply to them in the same way. Boy Scouts of America's First Amendment freedom of expressive association prevented the government from forcing Boy Scouts to re-accept Dale as one of their leaders in their group. And then it went to the appellate division, where New Jersey's public accommodation law applied to the Boy Scouts because it's a broad-based membership solicitation, and they rejected Boy Scouts' constitutional claims that they have the freedom of association to get rid of people that they feel like do not go with the views that they're expressing. And the New Jersey Supreme Court actually affirmed that, siding with Dale. I thought I'd bring up the counsel. I feel like that's kind of important in this case. On the left is Evan Wolfson. He was a lower level LGBTQ lawyer who did a lot of cases surrounding that in a very controversial time. And on the right here, we have George Davidson. He was a very high profile lawyer. And I felt that this was very important because it shows the money difference and how big of an effect that can have in cases. Boy Scouts of America was a nonprofit organization, but it did have a lot of money, a lot of revenue coming in, and they were able to afford this top-notch lawyer, whereas a college student was not able to. And whether that made a difference in the case or not is debatable, but it did not end up in favor for Dale in the long run. So the majority opinion of the Supreme Court sided a lot with freedom of association in the First Amendment. They were very strict on that. And they stated that the message of Boy Scouts of America was very clear in saying that they do not accept this. Boy Scouts of America brought to the case their handbook saying that they do not agree with certain things like this and that it would not look good for them if they had an LGBTQ member as their leader, even though it says they're against that. So the Supreme Court, the majority, supported Boy Scouts of America in firing Dale. They agreed with that decision. And then at the end, they said this is not whether or not they personally agree with this decision or if they personally agree with homosexuality, but it's more of doing their jobs to interpret how the freedom of association in the First Amendment should be interpreted. This was one of the quotes from the majority opinion, the Chief Justice. Forcing a group to accept certain members may impair the ability of the group to express those views, and only those views that it intends to express. Thus, freedom of association plainly presupposes a freedom not to associate. So just, again, supporting the decision of Boy Scouts of America to be able to be associated with members that they do and don't want to. A different case, a precedent case that they looked to a lot, even though it had a different outcome, was Roberts v. United States. In this case, kind of like Boy Scouts of America, there was a group called United States Junior Chamber, and this group only accepted males of a certain age. So they were discriminating against sex and age in that case. And then a chapter of that in Minnesota had anti-discrimination laws. So they went and accepted women, not just men in that case. And this case ended up going to the Supreme Court, where the leader of this group was like, I don't want anyone else but males in this age range going into it. And in this case, it actually had a different outcome, where the Supreme Court said this case lacked the distinctive characteristics that might afford constitutional protection to the decision of its members to exclude women. So in this case, they didn't have a clear enough message to discriminate against women. But in the Boy Scouts case, they said that Boy Scouts of America, through their history, has had a message against the LGBTQ community and therefore should not be forced to keep this member who goes against their views. And so in that case, they felt that there was a very clear message being shown, where in this Roberts case, there was not. In the dissenting opinion, we have Stevens, Scouter, Ginsburg, and Breyer, all very liberal justices. And they said that every state law prohibiting discrimination is designed to replace prejudice with principle. And they argued that homosexuality was not clearly in the handbook, which it wasn't. If you were to read the Boy Scouts American Handbook, there was not a very, very clear against the LGBTQ community, as clear as the majority might say there was. And the dissenting opinion also said that this does not require that every member of a group agree on every issue in order for the group's policy to be expressive association. And this was just prejudice facing the LGBT community at the time, which there was a lot of. During that time, they were facing a lot of hate, both in legislation and in society. This was after the AIDS movement, everything about that. They were already facing a lot of hate, and they felt that the majority opinion was just going off of very conservative views, as the justices that were in the majority were all conservative. So they felt that that was just not necessarily the case, but just against the LGBTQ community as a whole. And again, they said that there's not a clear enough statement against homosexuality on the matter, and therefore cannot be stated as freedom of association. This case was very important. Freedom of expression is not in a lot of Supreme Court cases that we see, and it became even more important. And in this case, it did make it easier to discriminate against LGBTQ community, because in the Boy Scouts case, there was not a huge show of being against homosexuality. So therefore, in future cases, it could be easier to discriminate on these cases and claim that they've always been against it and that there's a clear message, even if there might not have been, which was a huge loss for the LGBTQ community at the time. But what was a positive for that community at the time was it sparked an increase in LGBTQ rights litigation, as the decision against Dale sparked a lot of outrage among allies and people in that community. And Boy Scouts of America eventually ended up lifting that ban on gay youth members in 2013, which did make conservative churches withdraw funding, who they had put a lot of money into this organization as they felt it supported their cause. So Boy Scouts of America in the long run ended up losing a lot of money because of this decision. They did have a great amount of support in the year 2000 when they made this decision, when the Supreme Court supported Boy Scouts of America, but it ended up backfiring on them a lot in the long run. In my opinion, I believe the Supreme Court was wrong in their decision. I feel they used a lot of their own personal beliefs and what they felt their party might support in the matter. And I do agree with the dissenting opinion that this opens the doors for a lot of businesses and other organizations to discriminate both on sexual orientation and race and all those things, even if there is not a absolute clear message that they don't agree with that. And this was definitely a different time back then. That was over 20 years ago, where the LGBTQ community was not accepted as well as accepted as it is now. And I don't think if a case like this went to the Supreme Court now, even though the Supreme Court has a conservative majority, I don't think that would stand now. I feel like there'd be a very, very different decision in the year 2021. Thank you for listening, and that was my presentation.